Welcome to New Jersey Patriot News, your source for Second Amendment news in New Jersey and around the nation. I'm your host, Matthew Bartke. Today is Friday, February 9th, 2024. The State Supreme Court of Hawaii ruled Wednesday in Hawaii v. Wilson, reversing a lower court decision that found charges for carrying a firearm without a permit violate the defendant's rights, thereby upholding the man's conviction. In an astonishing opinion, not only did the court find against the defendant, but flatly rejected Supreme Court precedent and constitutional law, refuting the 2008 Heller and 2022 Bruin decisions that held the Second Amendment as an individual right and guarantees that right extends both inside the home and in public spaces. In the opinion, the court stated, quote, Article 1, Section 17 of the Hawaii Constitution mirrors the Second Amendment to the United States Constitution. We read those words differently than the current United States Supreme Court. We hold that in Hawaii, there is no state constitutional right to carry a firearm in public. In its rejection of the Supreme Court jurisprudence, the Hawaiian jurists wrote, quote, the spirit of aloha clashes with a federally mandated lifestyle that lets citizens walk around with deadly weapons during day-to-day activities. The 53-page opinion quoted both Hawaiian lore and tradition, as well as excerpts from HBO's The Wire as part of their reasoning. The Hawaiian Supreme Court's opinion may provoke the U.S. Supreme Court to take up the case as it did in the 2016 Caetano case from Massachusetts. South Carolina's House of Representatives sided with gun rights advocates yesterday, rejecting the amendments added to the constitutional carry bill in the last 2 weeks by the state Senate, and will instead be sending back a clean version of the bill to the Senate. South Carolina House Majority Leader Davey Hyatt issued the statement saying, quote, while I respect the intentions and efforts of the Senate, the House Republican caucus remains united in our decision to non-concur with the Senate's changes. We will return a clean version of the constitutional carry Second Amendment Preservation Act to the Senate next week, the exact version that was overwhelmingly passed by the House last year. Our dedication to protecting the Second Amendment rights of law-abiding citizens remains steadfast. It is our firm belief that this bill, in its original form, best reflects the fundamental rights and freedoms of our constituents. The Firearms Policy Coalition and Second Amendment Foundation filed a petition for writ of certiorari to the Supreme Court yesterday in the Bianchi v. Brown, formerly Bianchi v. Frosch case from Maryland, now with the Fourth Circuit Court of Appeals. The case, which challenges Maryland's assault weapons ban, originated from December 2020 and has been winding its way through the court system, with it being appealed to the Supreme Court previously in 2021 and being GVR'd or granted, vacated, and remanded back to the appeals court for reconsideration following the landmark Bruin case. Oral arguments were heard in the Fourth Circuit again in December of 2022, and no further action was taken for 13 months when the court ordered the case to be reheard en banc, or before the entire judicial panel, on January 12th of this year, before the three-judge panel issued any ruling. This controversial move mirrors those taken by the Ninth Circuit Court in similar gun rights cases. FPC and SAF and independent gun rights experts speculate this extraordinary and unusual move by the Fourth Circuit may have been to prevent an opinion in favor of the Second Amendment from being released. While it is rare for the Supreme Court to accept interlocutory appeals, the gun rights organizations feel the rare and unusual move by the appeals court may be cause for the Supreme Court to intervene. The 11th Circuit Court of Appeals issued an opinion today in the Firearms Policy Coalition-supported case, Balcom v. Jackson, that challenges Georgia's ban on 18 to 20-year-olds' ability to carry firearms. In a decision that also references the recent Third Circuit decision in Lara v. Evanchik, the court found in favor of the plaintiffs that they have standing and the case is not moot, and was remanded back to the district court for proceedings consistent with the opinion. This is New Jersey Patriot News, your source for Second Amendment news in New Jersey and around the nation. I'm Matthew Bartke. Thanks for listening.